Hello, good morning, and you're welcome to our first lesson in PPL324 Law of Torts 2. In PPL324, we're going to be looking at practical issues that arise in torts. And in this first lesson, we will start with the tort of nuisance. It promises to be very exciting because these are issues that you can relate with, especially living in our country, Nigeria. So let's go ahead. So, some of the things that you will learn at the end of this lesson is you'll be able to explain the meaning of the term nuisance. You'll be able to express an understanding of the general nature of nuisance, be able to identify the categories of nuisance, and analyze the defenses to nuisance, especially for private nuisance, and then you'll be able to explain the nature of damages. So what will be annoying you, but it will affect your health as well. So you would have heard people say, oh, someone is a nuisance or something is a nuisance. That's what we are going to be majoring on for this course. So while we were, you know, the industrial firm, you couldn't even hear what I had to say. So imagine that you had to live with that. So what is a nuisance? There is a legal definition and there's the everyday one. We are dealing with the legal definition. So in law, a nuisance is an actionable inconvenience or annoyance caused by the direct or indirect action of another person. It is also the negative effect of somebody's act or omission against the normal enjoyment of life of another. You see that we highlighted some words. So for something to be a nuisance, it must be an actionable inconvenience. It's not everything that annoys you that will be a nuisance. And then it must be caused by the act or omission of another person. And then it must impact on the normal enjoyment of the life of the supposed plaintiff. Now, whether something amounts to a nuisance or not is a question of fact. And for you to say something that amounts to a nuisance, it must be perceivable by one of the senses. So you can smell, you can see, you can hear, you can feel the negative effect and all of that. So gas emissions like we listened and we saw in the previous slides, noise from factories or from religious or social activities and all that, and then damage to buildings due to vibrations from industrial areas. All these will be examples. What you need to bear in mind is that there are two major types of nuisance. There is public nuisance and there's private nuisance. Public nuisance affects the whole or part of a people, a community. So it's not just one individual. And then it can be subject of both criminal prosecution and civil claim. Of course, you know that where it is criminal, only the Attorney General can institute proceedings. And then private persons on a general scale cannot claim for under public nuisance except where there's particular damage to them as a result of public nuisance. Now, of nuisance, private nuisance. So individual interests are the target of private nuisance and they can only be subject of civil prosecution. They can't be subject of criminal prosecution. Then, of course, only those people who have an interest in land can claim for private nuisance as against public, where the Attorney General can claim to protect, a whole lot of people. Now, there are three major categories of private nuisance. There is where physical injury, there's physical injury to the property of a victim of nuisance. What we will say in a claim, it will be the plaintiff. And of course, when we say property, we are not just talking about personal property, real property. Land is also property. Then, of course, second category is substantial interference with a plaintiff's right of use and enjoyment of his land. And of course, when we say enjoyment of his land, it doesn't mean that the person has to be the owner of the land. Someone who has possessory interest in a land can come under this category. Then, of course, we have interference with easements and profits. And easements are, intangible rights attached to land. So, right of way, right to light, right to air, and all that. Where this is interfered with, that is a private nuisance. So, quickly, let's just take one activity. Okay, we have talked a lot about what nuisance means, categories of nuisance, categories of private nuisance. So I'll need you to just test whether you have been listening and you understand what we're talking about. So the question is, how will you differentiate between public and private nuisance? I'll give you a few seconds to just think about the question and then we'll make progress. Let's go on. The question now is, who can sue for nuisance? Of course, you remember what we said, that if it is public nuisance, then the Attorney General can sue. Again, a private individual can sue for private nuisance. So anyone who has an interest in land can sue for nuisance. And remember, we said interest in this case does not need to be ownership, it can be possessory interest. Then the occupier or user of a land that is subject to nuisance can sue. And then the reversioner of land can sue if the damage occasioned by the nuisance will affect his reversionary interest. Those are the persons that can sue for nuisance. Now, who may be sued for nuisance? The general rule is that it is the creator of the nuisance, the party that is performed the act or omission that resulted in the nuisance, may be sued for nuisance. Now, that party may be a human being or may be a corporate party. Okay, and again, the landlord of a land, the owner of a land, can be sued for nuisance if he allowed or authorized or ratified nuisance in his property. So even if it was someone in possession that carried out the act of nuisance, the landlord may be sued if he allowed it or he authorized or ratified it in any way. And an occupier of land may be sued. Remember what we said, that it's not only ownership that matters, that possessory rights also matters. Now, the servant or agent or individual contractor of an occupier, if he acts in such a way that there's a nuisance, the occupier under whose authority he acted may be sued. And of course, where a trespasser engages in nuisance on property and the occupier of the property did not stop it, then the occupier of the nuisance of the property can also be sued. Now, what are the defenses against nuisance? So imagine a party is being accused of having committed acts that resulted in nuisance. What can the party say in his defense? One is that the act or omission complained of is reasonable. So for instance, if an area is a commercial area, you are within a commercial zone, it is reasonable that you would, industrial zone, let's use commercial. So you are within a commercial zone. It's reasonable that there will be a bit of noise because what's going on there is commercial activity. And then statutory authority. Again, an example, let's say someone is a contractor for the government and he has been instructed to build a road. Interference with easement rights of people, rights of way and all that, he will have statutory authority to do that. Then an act of God, of course, an act of God is outside human control, so that is a clear defense. Then the act of a stranger, you need to differentiate this between when we said a trespasser, where an occupier can be liable for the acts of a trespasser. The act of a stranger will be a defense if the occupier did not know about the act or he did not ratify the act, he did not allow the act, or where the act was taking place, he stopped it, then that will be a defense. Then, of course, consent. A party who has consented to an act that would constitute a nuisance cannot go back and complain when the effects, he starts to feel the effect. Okay, so when you're a party is claiming damages for nuisance, the general rule is that nuisance is not actionable per se. When we say something is not actionable per se, it means that you need to prove the damage, otherwise you cannot, the court will not award it. So it's not enough to just say I suffered damage. The court will need a party to prove how he suffered it and the quantum of damage and all of that. Now there are exceptions to this general rule. One is where the facts are so overwhelming that damage is readily presumed. So industrial activity next to a residence where there's constant noise, emission of noxious gases and all of that, poisonous and effluent discharge, the facts will be so overwhelming that one can definitely presume that there will be damage occasioned by such acts. Then where easement rights are being interfered with, of course, easement rights are intangible, so it can be a bit of a problem proving, damage from intangible, interference with intangible rights. So there's a presumption of damage where it is proven that there's an interference with intangible rights. And then where there is fear of imminent harm, where a plaintiff, activities of the defendant are such that it may result in harm to the plaintiff. The plaintiff does not have to wait for damage, to suffer damage. He can go to court and seek an injunction to stop the defendant from continuing with such. So now let's take a second activity to deepen our understanding of what we have been talking about. And the question is, if you were sued for nuisance, so imagine you are the defendant and your neighbor has sued you for nuisance, what factors will you explore as defenses against such a claim? So I'll just give us a few seconds and then we'll make progress. Going on, some of the things we have learned in this lesson are: one, we have been able to define nuisance from a legal standpoint. Then we have mentioned the categories of nuisance. Do you remember them? We said there's public and there's private. We have, in discussing these categories, highlighted some differences between public and private nuisance. We have talked about the defenses a defendant may have against a claim of nuisance. And then we have also discussed the damages for nuisance, the fact that damages for nuisance, a nuisance is not actionable per se, and then exceptions to this general rule. Now, if you have any question, download the video. You're allowed to download the video, watch it again and again and again. And then if you have any question, feel free to discuss it, post it on the discussion forum and then we'll talk about it. Okay, so I'll see you at our next class. Bye.